to trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. The Sweet Peas on the mic with that spicy little vibe. Got the courtroom streaming in the chat going wild. We're debating heavy topics but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when Sweet Peas in the building, we be learning with pride. Minds on deck, keep the room running smooth. Film freak therapist, you know, keeping everyone in the groove. Right to with the facts, pretty brown girl with the sass. Moreldia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate, take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know Sweet Pea breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you're out of line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. When the sun goes down and the cases get deep, after dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. Sweet Pea says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made a goal. Hey! Take it to trial, from day to night and every wild mile. Sweet Peas kneeling strong with her trademark style. And the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial, yeah, we live tonight. Take it to trial, yeah, we live tonight. Take it to trial.
Good morning. Good morning. I think it's still morning for most of you guys. Good afternoon to the people that good afternoon goes to. We know Christine, she's first up in the place as always. Christine, hopefully you've seen on a thing. I think the membership, don't quote me, I think it's $3.99. I think for the drama packet. Good morning, afternoon, Merelda. Good afternoon, Merelda. Hey, Allison. Hey, I am. Howdy, therapist. She got on the cowgirl hat. You got cowgirl boots? I'm pretty sure you do. Wow, wow, wow. So today is very interesting for us, if I must say so. I should have bet you. Boy, oh boy, I probably won't have to sing you no cowboy hat, depending on what they decide when we go in this court. Because I heard from a little birdie, somebody that knows something about something that knows something. I heard this is not going to sit well in regards to that trial. And I think that we may be headed towards a mistrial. That's in our school shooting case that we'll get into later this afternoon. I am sure I said it's not going to happen. I don't know. I always want to bet now because I'm telling you, I think it could. Oh, I don't know. I heard that is very possible. And I was like, really? I was like, oh, I should have bet. I should have put all my marbles in one bucket. Let me see. Okay. You say you seen worse? I don't know. I don't know. So I don't know. Let me see. It looked like we got a lot of hearings today. I didn't want to have us flipping and the flopping and the flopping and the flipping. And I know y'all will hang out with me and do all of those things. But I was trying to make our stream a little bit easier. I know Kouri Richins is another big case that's coming up. That I don't know. I know personally myself. I really want to see how this case is going to go. Um, so with her hearing this morning, I definitely want to pop in to see that. Um, it's supposed to be a 2-day hearing, so we'll work it out however we need to work it out for that. In the meantime, in between time, I know that Nick Reiner was supposed to have an arraignment this morning. I'm not sure if it started or not, to be honest with you. It was supposed to start at 9 o'clock, but I don't think I see where it happened. But don't quote me. I'm just on here. I'm on YouTube and I'm trying to see what has happened and what is currently happening. Yeah, they still have it upcoming. So it was supposed to start at 9 o'clock. It has not happened. We have Kouri Richins. Hers supposed to start at 9:30. Of course, it's 9:41. It has not happened. What I've learned from all of these places that they be telling you that the hearing, I think they just want to get the rooms together and get people in their waiting and kind of let everybody have a seat and get settled. As far as I'm concerned, her hearing probably don't start to 10. So, with that being said, we won't mix too many things. I don't think his hearing has started. So let's go here. You say you seen worse? Hi, we are getting a delayed feed on this hearing, and we should be up around 12:08. There you go. I knew it. 10:08. So they getting a delayed feed. So there we go. That's why we don't get anything. I just seen a note from Law and Crime. Shout out to Law and Crime for covering this. Let's see here. So that won't start till about 10:08. Just so y'all aware. In the meantime, in between time, let's do this. So this is her last hearing that she had. It was about 4 weeks ago. Let's tune into this, watch a little bit of this. Oh wow, they thing is looking so awful. This is another one. They would not let her out on bail while this trial was going on. You said, let's get your me. You want to get size for your hat? I don't know. You might be speaking too soon. Oh no. So this is a hearing that was held on. I don't know how many of you guys seen it. It was held. I watched the PBS special on that last night, guys. I found it to be very, very interesting, all the different accounts and stuff in regards to that. So if you haven't seen it, it may be a good thing. I guess depending on how much you want to listen to it, get involved with the case. But it may not be a bad listen to if you have an opportunity. I don't know. It kind of put me back in the mindset of all of them still need to be on trial, or you need to probably sue them. You need to sue the city for not having stuff in place because it just sounded like nobody knew what to do. But that's just me. Yeah. So let's watch her hearing that she had a couple weeks ago. which is going to be setting the stage for her. She is supposed to go to trial next month, and for allegedly poisoning her husband. Now they say she poisoned them with fentanyl, I believe. I think it was fentanyl. But the person who they said sold the fentanyl to her said that they didn't sell the fentanyl to her, that they sold her a different type of drug, some, I think, want to say Percocets or some kind of opioid. But so they tried to get her out of jail based off of that information. But the state is saying that, hey, no, we still have enough evidence that regardless, we don't care what drug he had in his system, she gave it to him. So a lot of the stuff that we will see in these pretrial hearings today, and like this motion that we're about to get into, is information that most likely the jury won't see. This is handling a lot of things out of the jury's presence so we can have a smooth running case if possible and don't run into different issues like what we're running into with our other case. So we'll watch this, and once it's completed, at that point in time, we should be ready to go into the actual court feed for today. All right, guys. Okay, here we go.
New set of charges. We've handed you a copy of the information showing them. Do you have that? Okay. I don't need to read it to you unless you'd like me to.
We've read it.
All right, very good. I am appointing Wendy Lewis, Catherine Nestor, and Alexander Ramos to appoint to represent Ms. Richins in case ending 162. At least through the first scheduling conference in that new matter. And we're going to set that. How about April 17, Council? Is that agreeable? Mr. Bloodworth?
Yes, sir.
At 1:30 p.m. April 17, 1:30. Mr. Bloodworth, anything else on the new case?
No, sir.
Will you let the county know that I'm appointed?
Okay, sorry, Your Honor.
That's okay. April 17, 1:30 p.m. for a scheduling conference. We, Brittany, will inform the county manager that you've been appointed on the new case through that date at least. Okay. Anything further on that case, Ms. Lewis?
No, Your Honor.
Okay. Let's return to case ending 139. We're here for a pretrial conference. Mr. Bloodworth, what is it that your team wanted to address today?
Your Honor, I think we should briefly discuss the, just to kind of maybe review what we're expecting for January 7th and January 8th motions hearings. The state then would like some of the court's guidance on filing, whether the court prefers non-public filings in the motions in limine practice and subpoena practice. We should probably touch on jury instructions a bit. The parties have reached an agreement to extend some of the briefing deadlines that we'd like to put on the record, I guess, or just let the court know.
I saw those. We'll talk about those. We can go over those. I just need to make sure I have enough time to read, so I'm prepared for the 7th and 8th.
Understand?
Yeah.
And then there's one kind of reminder for the court that Greg White's motion for a protective order, docket 933, has been fully briefed and requests to submit for decision.
Is that? Yes, I recall that from the first trial setting. It was unclear whether that was mooted by the resetting of the trial.
I don't
Has he
think
been
so.
re-subpoenaed
Exactly.
to appear?
Right.
Okay. Okay, it's on the list. I got it.
That was what was on the state's mind, Your Honor.
All right. Let's talk about January 7 and 8 first. And perhaps you can all give me a better sense of what has not yet been filed but is likely to be filed to be heard on those days. So in terms of things that were filed prior to the first trial setting that have not yet been decided, I think there's defendant's motion to exclude the state's expert witnesses, which is fully briefed, right?
Yes, sir.
Are we anticipating any supplementation or amendments on that one?
No, sir.
Yes, sir.
Yes.
They just, noticed up a brand new expert, and I anticipate adding him to the list of people that I want to exclude under 702.
Will it be a new motion telling me why that particular new
Yes.
person? Okay.
But I mean, you asked about supplementing it. I'm probably just going to, it's going to be a new motion, but
Right.
it makes sense that we hear all of them together. So I look at that as just like one more objection under that ground.
Yeah, I think, with Rule 702 motions, right? The
Correct.
devil is in the details.
Correct.
So it'll have to be specific to that expert's
Of course.
proper testimony. Okay, I understand. So another expert-related motion to exclude is likely coming.
Yes.
Okay.
In Your Honor, I think the parties are in agreement that the experts, I guess whoever they are, on January the 7th can appear by WebEx.
Okay, very good. Are we doing any of, and forgive me, I didn't go back and pull all the briefing. To what extent will we be doing any of their, or viewing or reviewing any of their expected testimony and declaration, or are they going to do a trial run on the 7th? How much is happening on the 7th? What's your expectation, Ms. Nestor?
So
Have you received summaries or reports from the experts?
we have received both, actually. My only concern about it is if we only rely on the summaries and the declarations, that if we don't prevail on the motions and then it expands at trial beyond what we argued, then we're right back to where we started. So it would be my preference that the experts take the stand and make sure that we fully understand, exactly what the limits of their opinion will be, is so that the court can rule on it all at once.
I don't know that we've set aside enough time for that kind of exercise.
3, 4. We have, so right now the experts that have been challenged are the FBI profiler,
Right,
the domestic violence expert,
right,
the handwriting expert,
sure.
and then this new one. So there will be 4.
Okay, so let's take the domestic violence expert
Right.
as an example. I understand your position to be there is no factual nexus between that type of expert in this case. Under 403, it shouldn't come in.
Right. We also have issues with her qualifications.
Okay.
Yeah.
Her qualifications are what they are. Either
Yeah.
they meet the standard. There's no allegation that she's lying about them on her CV, right? They're either
Right.
good enough or they're not.
Right.
Okay. What does she need to testify about on January 7th?
Well, the nature of her opinion. So it's my understanding that she's
Haven't you received a report or a summary of them?
a summary. Yes.
And based upon that summary, you're persuaded that there's no fit, to use the word, the 702 language between her opinion in this case?
Right.
Your Honor, if I may jump in on 2 things. 1, I don't believe they've consulted with her yet. And 2, she's not offering an opinion.
Then why is expert testimony appropriate at all?
She's testifying about characteristics of domestic violence relationships, but she is not offering an opinion as to the relationship between the defendant and Eric Richins.
Understood. She, as I understand it, will be offering specialized knowledge that is beyond the knowledge experience of a lay juror.
Correct.
Okay. And then the state's intention would be to make argument using her testimony as foundation.
Correct.
Okay. I understood that. I'm not precluding you from asking that person questions. I'm just not sure we'll need much to fairly address your arguments regarding that testimony.
I agree.
The FBI profiler, I just don't know. We'll find out, I guess. Mr. Throckmorton, there I can appreciate why you might want to voir dire him a bit about what he didn't do, didn't look at. I think we'll have sufficient time for that. Do you have he usually produces a report with exemplars. He has a standard form. You've received that. So you'll be able to jump right in with him on the 7th. You wouldn't need the state to lay any direct testimony.
No.
Okay. And then who's the new one?
It's, I mean, I guess let Mr. Bloodworth answer that.
Your Honor, it's a detective with experience in.
Oh, that's right. Yes. Illicit drugs in Salt Lake County in a certain time frame.
Correct.
Got it. Okay. And you've received a summary or a report?
Your Honor, just a summary.
Okay. All right. Well, I stand corrected. I think we'll be able to get this done. Whether I'll be able to rule on all this by the end of the day on the 7th, I'm less certain on, but we'll figure that out. Okay. All right. And then I'm jumping around here a little bit, I apologize. Would the intention be to hear oral argument on as many of the motions in limine that the court wants to hear oral argument on the 8th?
I think that makes sense.
Your Honor, that makes sense. I think there might some, I guess, depending on what the court's interested in hearing, might require testimony.
Give me an example a little bit. They'll be fully briefed, right?
Yes, sir, they will be fully briefed. Your Honor, some of the factual allegations in the defense's motion in limine, I don't think they're supported. It's not like a lot of times the state can say, we agree to this proffer because we know you could prove that.
Right.
I don't think that's the case through many of the factual assertions in the defense's motion in limine.
Which, give me one that sticks out in your mind. I perused some of their defendant's motion limine. I thought I looked at it.
Mm-hmm.
Are you trying to say that their characterizations of what the state would be seeking to admit are not accurate?
Your Honor, there is that in the motion, but I also think that we can address that in the written briefing.
Right.
I think that the some of the factual allegations, I know there's not a facts section of the briefing, so it's just difficult to, in a sense, tease out the factual allegations, but there are factual allegations. Paragraph 1, after the death of her husband, Ms. Richins and her son wrote a children's book together. That
I don't need to make
to
that
the extent
finding,
to the extent the court that's just the first example, but
Okay.
to the extent the court needs to make factual findings, there may be a need for the court to take testimony.
Okay. I think to the extent there is a dispute about what a piece of evidence says or doesn't say, what a witness is going to be offered and testified to or not, there may need to be some back and forth among counsel. Hopefully that'll get teased out in the briefing. We may need to lock some folks in. We also need to recognize that, especially with live testimony, sometimes witnesses turn left instead of right, and we're going to have to be a little bit nimble during trial to say, well, that ruling no longer applies. We have to make some amendments. So,
Yes, sir. So my sense is since we'll be together on the 7th, if at the latest on the 7th, but as early as possible, if the court recognizes potential factual disputes and will give us a heads up, we can have witnesses ready.
Okay, I would hope to do it before then. This is a good way to back into, under your stipulated extensions, when will the motions in limine that you can contemplate sitting here today be fully briefed?
Your Honor, the agreement that the parties have reached really only relates to the defense's motion in limine, and it is a 1-week extension for the state's response and an additional week for the defense's reply. That would put the state's response due on December the 24th and the reply due on January the 7th.
All right. Can we move the reply date a little bit?
January 5th, that one.
Yeah, at least then I can read it on the 6th. Okay. So that would be defendant's reply in support of their motions.
Correct.
Okay. January 5, Ms. Lewis.
Yes.
Thank you. Mr. Bloodworth, I need a binder and a thumb drive on January 2nd. And it needs to have, the binder needs to have the briefs that I'm considering on the 7th and 8th. And the thumb drive needs to have PDFs of the brief plus PDFs of any exhibits.
Yes, sir.
Okay. Understanding that the reply brief we just talked about won't be in it.
Sure.
Okay. All right. Okay. Back to the list. We've talked about defendant's motion to exclude the state's expert witnesses and a forthcoming additional motion in that regard. We have the state's motion to determine the admissibility of the walk the dog letter. That is now fully briefed and just submitted for decision, correct?
Correct.
Your Honor, actually, that was submitted for decision 8 months ago. I can do it in writing, but I object to the reply that was filed 8 months later and move to strike the reply.
If you do it in writing, give your reasons why, and then we'll give the state an opportunity to respond to the motion to strike, and I'll consider it. Okay. State's first notice of intent to offer 404B evidence, that has fully briefed, but there's a second notice, correct?
Correct.
Is that second notice fully briefed yet?
Your Honor, it hasn't been briefed at all.
Okay. Is there a plan for briefing it?
Your Honor, we've not discussed one. But
Okay.
the state's open to whatever.
We're going to respond before the 12th as
Okay.
we were directed. And then I guess they can reply. So I thought we had a briefing schedule for all the motions that were filed on the 26th, I believe. According to the docket, our response is due by the 12th.
Okay. Very good. Mr. White's motion for protective orders on the list. I haven't lost track of it. There were additional motions limited filed by the state recently, correct?
Yes, sir. And may I note too, there's the motion in limine related to the orange notebook that was filed back in, I don't know, early 2025 that has not been fully briefed
Or submitted for
or
decision.
submitted. But we spoke with defense or emailed or something with defense counsel the other day. They know it's out there. They plan to submit a response.
Okay.
And then the state will either reply or submit.
I know it seems silly, but in any docket, and especially one of this length and complication, the request to submit is literally how the court knows whether to pay attention to something or not. It's the difference between me leaving open the possibility that you all worked it out in the process of the briefing versus knowing I need to pay attention to it and how quickly. So please follow that procedure so I make sure I don't miss anything. Okay. Let's talk about private versus non-private. I take a rather expansive view, especially given the proximity to jury selection, of what can be filed privately in this case, especially if counsel agree. If you all agree that a specific particular return of service or all returns of service, subpoenas or all subpoenas, all motions in limine should be filed privately to prevent incomplete, misleading, or just absolutely inaccurate reporting of the content of those documents from poisoning the jury pool, I will not get in your way.
Understood.
Any objection, counsel? No. Yeah, you don't need to. The procedure that the parties have been following on both sides of the V is acceptable to the court. The benefit of doing it as a private document is that you all can see it, I can see it, court staff can see it, the public cannot. And there's good reasons for that given the proximity to jury selection.
Yes, Your Honor, the state appreciates that. The state would ask, just as a courtesy, if counsel files non-public, if they could send us a courtesy copy. We don't have access electronically to non-public. We have to walk down to the court's office.
Is that true?
It is.
Don't you have the same green filing access that everybody does?
We don't use green file, Your Honor.
No. Is that a government thing?
It's a government thing.
Oh. That is news to me. I apologize.
And so the state appreciates the non-public filing this close to seating a jury, and,
Right.
and the state will engage in it itself. But filings after hours are,
Right.
we don't get them till the next morning. When we walk down.
Is it a simple matter of your office just buying a green filing account for a couple of months?
It may be. I don't
Okay.
know how it works.
Fair enough. I'll let you all work that out. I did not appreciate that. Okay. Yeah, there may be a way we can work around that for you.
Thank
Okay. Okay. Ms. Lewis, Ms. Nestor, Mr. Ramos, anything on that? You folks, through green filing, are able to see it instantaneously, right? Correct. Okay, very good. Any objection to what I've just proposed?
No.
Okay. All right. The juror questionnaires are scheduled to go out on December 16th. You've received a copy of it. We included the changes that Ms. Shervanek emailed over after a meet and confer some months ago at the end of October. One additional question came up. Do we want to include a single additional question asking the juror if they're paid hourly or salary? I don't know if that's something you'd want to know when culling or creating categories. There are certainly other fields where someone who believes the financial hardship would be too great would have an opportunity to tell us. Yeah. If you're comfortable with the way it is, that's fine.
We're fine with the way it is.
Okay. Ms. Shervanek.
Yes, I'm fine with the way it is.
Okay. Very good. We are intending to send questionnaire responses to counsel on or before January 19th. Those will come in the form of a PDF and an Excel spreadsheet. We are also keeping a separate Excel spreadsheet of people that the court strikes in advance of them filling out the questionnaire because they tell us, hey, I'm going to be in Europe for 3 of those weeks or things like that. We'll keep a record of it so you'll be able to recreate it if necessary. Okay. Anything else on jury selection, Mr. Ramos? No objection. Okay. Ms. Shervanek?
No.
All right. Did we get through your list, Mr. Glenberg?
Your Honor, jury instructions.
Yes.
So at this point in time, we've gone back and forth. We have a proposed set of jury instructions, and then a separate document that lodges some defense objections. How would the court prefer us to submit those?
I recall in the run up to am I recalling this correctly, in the run up to the last trial, there was the stipulated set, then there was a set of defense proposed that were not stipulated, and states proposed that were not stipulated. Is that accurate?
That is not, Your Honor. We never got to jury instructions
Maybe
in the run up
thinking
to
of
the
it. Okay.
prior trial. This is our first go at that.
Okay. I thought we had it. Yeah, and my apologies. I'm getting my cases confused.
Sure.
That's typically the most helpful, is a stipulated set with citations to authority, if in the footer, if possible.
Right.
And then to the extent that the state or defense has a subset of proposed instructions that are not stipulated, just submit those separately with citations to authority. The real question is, to what extent do you want to be able to talk about your instructions during your openings? If you do, we need to come to rulings regarding as many instructions as possible prior to giving openings. If you're less concerned about that or have no intention of doing that, we don't. Some instructions we simply won't be able to finalize until we see how trial proceeds.
I think probably the only one we would use in opening would be the presumption of innocence and burden of beyond a reasonable doubt, which we've stipulated in those two. So, well, there's one additional one we're asking for. So we might be able to just resolve the ones we want to use for opening, and then whatever ones they want to use.
Are there, without getting into too much detail, are there any live disputes or genuine disputes regarding what the elements of the charges are?
There are.
Okay. That seems like an issue that we should try to resolve prior to it.
Agreed.
Okay. All right. Bear with me for a moment. If if I canceled a civil trial, I could liberate February 19. Do we want to talk about your instructions on February 19th?
Yes, it's fine.
Okay. It's the day after the last scheduled day of jury selection. I'm cautiously optimistic we will have picked a jury by then.
That's a Thursday, correct?
It is. Okay, let's plan on we plan on 1 p.m. on I have a criminal count. I have a criminal count on Wednesday. 1 p.m. on February 19th in person for a discussion of jury selection. Jury instructions. My apologies. Ms. Nestor, does that work?
Yes, Your Honor.
Yes, sir.
Okay. In that case, what I'll need is given that it sounds like there's a dispute regarding the elements of the charges, just a little bit of briefing. It doesn't need to be long, but I just need to know what your position is and why before I walk in on the 19th. Something along the lines of a pocket brief, a citation to authority, a little bit of discussion so I can know what you're relying on. You can only do so many things at once. Can we have those briefs just cross in the mail and be filed on February 9? Does that seem workable, Counsel?
Yes, sir.
Mr. Bloodberg?
Yes, sir.
Okay. Very good. Mr. Bloodberg, keep going.
Your Honor, that's all the state
Mr. Ramos, Ms. Nestor, Ms. Lewis.
We have nothing else.
Could I persuade you folks to just check in with me on January 2nd to make sure we're on track? Is that workable? You can even do it by WebEx if you prefer.
What time would you want to do that?
The afternoon. Brittany, would you recommend the afternoon? In the afternoon.
That should be fun.
Do you want to say 3 p.m. on January 2nd? Would you like to do it in person or by WebEx?
WebEx.
Okay. Mr. Bloodworth, Ms. Sherman, is that all right?
Yes, sir.
Okay. Let's have a continued pretrial conference on January 2 at 3 p.m. to make sure we're on track. Give me just a moment. Mr. Bloodworth, there is a motion to reconsider the severance.
Yes.
When will that be fully briefed under the same schedule?
No, sir, that schedule's advanced. We didn't shift that schedule, so it's the normal. Actually, you gave. Yeah, so next Wednesday will be defense's response. So that's the 10th, and then the state's reply would be due December 17th.
Okay.
The docket says that all of our responses are due on the 12th, so if we could just clarify. We thought, I pulled up the docket, it says the 12th.
I don't have the dog in this fight because I won't know about them until they're fully briefed. But if you have any, I mean, I'm sure you and Brad can.
I don't care if it's the 12th.
Yeah.
We may have some on the 10th. I just don't know yet.
Okay. I haven't read it. I only looked at the caption,
Sure.
but that feels like one that I could rule on the briefs. Any objection?
No objection. I think you can roll on the briefs.
Okay, very good. I will endeavor to get a written ruling out on that as quickly as possible,
Yes.
so that you folks know whether you're trying the amended information as it looks now or something else.
Yes, sir.
Okay. All right. Let me just pause for a moment, see if anything else comes to mind. Go ahead. I imagine they're going to come in with the briefs on January 9th. I'll be more explicit. January 9, I need your briefing on jury instructions to the extent they're disputed in your stipulated set. That's a February. My apologies.
Right.
Yeah. Stipulated set, disputed set, and why I should rule one way or the other on the disputed instructions. Jury instructions tend to be an iterative process in any case in general, and certainly a case of this size. And so we may have to discuss them over time as we iterate through. Okay, let me go around the table one more time. Mr. Ramos, anything else today?
No, Your Honor.
Okay, Ms. Nestor,
No, Your Honor.
Ms. Lewis.
There.
Okay, Mr. Blood,
No, yeah.
Ms. Sherman,
No.
Mr. Burmester.
No. No, Your Honor.
Ms. Olson. Okay. Counsel, I appreciate seeing you in person. I look forward to working with you on this case. We'll be back together by WebEx on January 2 at 3 p.m. If anything comes up between now and then, I'll do my level best to make time on my calendar.
So let me see if they started the actual hearing for today. Let me go check in here. My name's Sweet Pea. Ricky, how are you? Let's see here. I Sweet Pea Diamonds. Okay. Let me go in here and see if I can find out.
We don't know which theories, of course.
They gave.
The pathway to violence is first. I think that if
I don't know. This attorney's voice is gonna drive me nutty,
I
buddy.
understand. Appearance, please.
Nutty, buddy. Hey, Only, how you doing? Okay, here we go. We are in court live.
Good morning, Your Honor. Brad Bloodworth, Margaret Olson, Lindsay Shervanack, and Fred Burmester for the state.
Very good. For the defense.
Wendy Lewis, Catherine Nestor, and Alexander Ramos for the defense.
All right. Counsel,
Ms. Richins is present.
as I understand it, we're here today to address the defendant's motions to exclude 3 of the state's experts. Is that correct, Ms. Lewis?
Yes, Your Honor.
The states recently filed a motion to exclude one of the defendant's experts not on the list for today. We'll address that in some fashion in the future. Yes.
Yes, sir.
Okay. Ms. Lewis, do you have a plan on how you want to proceed?
Your Honor.
Oh,
Sorry
it's
to
the
interrupt.
preliminary matter. My apologies.
Just thank you,
Yeah.
Your Honor. May I
Of course.
Your Honor, the state wants to ask the court to make additional findings in connection with its order from yesterday denying the state's motion to determine admissibility of evidence. The court's findings regarding the defendant's financial crimes as it relates to the state's pecuniary gain element argument is clear. In its briefing, the state raised 2 additional arguments that the state asks the court to address. The first is that the defendant caused Eric Richins' death to cover up her financial crimes, and this proves an additional motive as well as the identity and intent elements. And the second argument is that the defendant's...
I'm sorry, no, I just am having trouble hearing. I need you to pull down the mic. Thank you.
And the second argument, Your Honor, is that the defendant's financial crimes show that causing Eric Richins' death was her last resort, and this proves the identity and intent elements. The state asks that the court make intrinsic evidence findings on these 2 arguments and additional findings under Rule 404, as these additional arguments increase the probative, in the state's view, increase the probative value of the financial crimes evidence. Finally, Your Honor, regarding footnote 3 of the court's ruling, the state asks that the court note that the state advanced its complete the story argument in its moving papers before Blackwing issued, and then in its reply papers revised its argument to comport with Blackwing. Thank you, sir.
Yeah, let me be clear.
Yeah.
I understood your arguments. I just didn't find them persuasive. The state simply hasn't carried its burden to show a sufficient or persuasive basis that the arguments you just described satisfy the legal standard for intrinsic
Sure.
or provide a sufficient or persuasive basis to avoid the court's view of the balancing of the propensity inference that is most likely to be drawn under 404B, which implicates the 403 analysis the court made.
Your Honor, I appreciate that. And I don't think that comes through in the ruling. I think the ruling very clearly and specifically addresses the pecuniary gain. And the court, may have built in its thinking as to the other 2 of the state's arguments, but I don't know that that is reflected in the ruling. And I think it would help if it was.
Okay. I understand your position.
Okay, thank you, sir.
Anything else on a preliminary basis?
No, Your Honor.
Okay. Very good. Ms. Lewis, my apologies. No, it's okay. You can sit down. Oh, go ahead.
Your Honor, I did want to ask, can I move in and out of the courtroom as business requires?
Out of the well or out of the courtroom?
Both.
Yes, that's fine.
Thank you, sir.
Thank you. Ms. Lewis, we're here to talk about 3 experts. Happy to handle those in any particular order. Happy to have some legal argument and colloquy before or after taking testimony if necessary. What's your view of what the defense needs to do today?
Well, we're handling different experts, but if we could maybe handle Ms. Amon and Dr. Fox first, I think that if Ms. Amon were to testify and then Dr. Fox, and then we could handle that, and then Kathy, you're doing
The other two.
and then Ms. Nestor's doing the other 2, so I don't know if you prefer an order on those. So either order on the others.
And forgive me, with respect to Dr. Fox, nobody's challenged her.
No, she's going to testify if the court needs to hear it about the scientific reliability of the pathway to violence and why it should be excluded as under 702. Based on her
Let's
expert.
talk about that structurally.
Okay.
If I have one former FBI agent saying this is not the way we do it in the behavioral science realm, and I have another former FBI agent saying this is how we routinely do it in the behavioral science realm, doesn't that go to weight rather than admissibility?
Well, possibly, but I think it might be more extreme than that. And that's why I think it's important we hear their testimony. From my understanding, that the pathway to violence has not been used particularly in courtrooms and doesn't come anywhere close to meeting the reliability standard under 702. And Dr. Fox, formerly when she worked for the FBI, also worked in this area and has a lot of information about how that study was conducted. And it could be a balancing act, but I actually think it might be such a huge difference that it would go to admissibility and not wait.
Okay. I have some questions for the state on Ms. Amon first.
May I just briefly address the court?
Sure.
Then Ms. Sherbernack will address Amon.
Okay.
Your Honor, because it's the state's belief that the defense has not even met its minimal requirements under Rule 12.
To do what?
That they specify sufficient legal and factual grounds for the motion. Now, even assuming the court disagrees with that, the papers sufficiently address the threshold showing. As the court is well aware, after Ramash, after cases like Clopton and Gunn-Hildary and the new Rule 702 flipped Ramash, which tended to keep a very narrow gate to allow very few witnesses through, it sort of flipped it upside down so it catches almost anything. And even if there's 2 witnesses who say the opposite thing, they can still come in under that new 702. And by virtue of the papers, the state believes it has met its burden of a threshold showing. Now, the court wishes to address specific issues. I just wanted to lay that groundwork. If the court has specific questions, we've got all our witnesses ready to go, as the court can tell. Mr. Throckmorton is here, and then the other 2 are on the line. So if the court wishes to proceed on to specific questions about Ms. Amon, then Ms. Sherbernack can address that.
I appreciate the argument. The defendant's initial briefing was certainly sufficient enough for the state to file an opposition brief that had legal analysis, citation to cases, and consideration of the specifics of each witness's testimony. So the state's argument regarding the insufficiency of the defendant's initial briefing is respectfully rejected. I have specific questions regarding each witness within the framework that you described, 702, and then if we're past 702, we have to deal with Rule 403, maybe. Whose witness is Ms. Amon?
Ms.
Ms. Sherman, I
Sherman.
can ask you some questions.
Of course.
You just got to pull that mic closer to you. Okay. In its brief, in opposition to the defendant's motion to exclude Ms. Amon's testimony, on 2 occasions and in bold print, the state says Ms. Amon may become helpful to the jury. Under what set of twists and turns at trial do you see Ms. Amon testifying? Is it in the state's case in chief, or only potentially in the state's rebuttal case, depending on the arguments and other testimony that comes in from the defense case?
The latter, Your Honor. It would be part of our rebuttal case, depending on what potential theories, evidence, witnesses come in through defendant's presentation.
And one of the examples the state gave was, forgive me, that in the state's view, Ms. Amon's testimony may be helpful to the trier of fact to rebut an argument that, hey, this doesn't happen like this. This is not the way violence gets committed. Wives and mothers don't suddenly kill their husbands. And I understood the state to be saying, well, there's a progression here. People form this plan, unless it's the emotional pathway to violence, but this planned pathway to violence has a progression. It's been studied. This is how it works. Am I inferring the state's argument correctly?
In part,
Okay.
I think we don't know which theories, of course, defendant will put forth, but there are multiple theories that could come out at trial where Ms. Amon's testimony becomes relevant to assist the jury in placing the facts and evidence that they have heard into an analytical framework. And again, Ms. Amon's testimony, and I don't think this is clear from the defense's objection or from their reply, she is a blind expert. She
Right.
will not be saying Ms. Richins, and also from the declaration from Dr. Fox, they seem to all miss the point that Molly Amon will not be saying Ms. Richins fits this profile, therefore she committed murder.
Right.
That's not the testimony. That's not what we would elicit. We agree that would be improper, and that's not our intention with Ms. Amon's testimony. It's more to assist the jury in a framework to understand how targeted violence occurs. Again,
Sometimes, right?
well, yes, but also Ms. Amon could describe that in every targeted act of violence, and this is part of her proffer, that there is a framework, a pathway to violence that perpetrators of targeted violence follow. Now, do they complete a couple steps and pause? Do they all follow the same timeline in the exact same sequence? Maybe not necessarily, but there is a framework of perpetrators of targeted violence who follow a pathway to the attack. And all of the targeted acts of violence that have been studied, the perpetrators follow this framework to some extent.
Okay. When you say all, you provoke some questions regarding the Diaz versus United States case that was cited in
Sure.
Defendant's brief. Now, in fairness, that case has a holding that goes the other way, right? That said the expert there said, most cases it works like this. Most people that are transporting drugs know they're doing it. And a majority of the United States Supreme Court said, that's fine under Rule 704B. That's not a implication regarding the defendant's mental state or what was in their mind, because it's most, not all. And is Ms. Amon in that bucket of blind experts, or is she going to say, no, this is how it works every time?
I think we would have to ask her that direct question. I mean, and she can explain to the court what her answer to that is and why. But I think to say all the time, always, is extreme. I don't think that's what Ms. Amon's testimony would be, but I would rather not speak for her. If that is in fact what her testimony would be, then we need to address that and explore it. But again, when we're talking about a retrospective analysis, which is part of what she's talking about in the studies of the pathway to violence, they know that these perpetrators have committed the ultimate act, right? They have perpetrated their attack. So that is a different analysis than to say, are there other folks who have started on the pathway to violence and not made it to the ultimate act, to the attack phase, if you will? Yes, those people exist. And Ms. Amon would not know who those people are.
I read her proper. She seems to explicitly acknowledge that people stop at various points
Right.
along the pathway.
That's my point. So
Okay.
to say that if you start on this pathway to violence, you ultimately will commit an attack regardless, all the time, always. No, that's not her testimony.
Okay.
And that's not factual. But for her to say in all of these multitudes, decades of studies of people who have committed a targeted act of violence, we know the end result. The attack has occurred. We can place those folks on a pathway to violence. We can put them on these steps and identify the steps that they took to that attack.
Okay. All right. Hold on a second, Ms. Lewis. Anything else you wanted to say at this point, Ms. Sugar?
Not unless the court has additional questions on that point.
No, I understand the state's position. Ms. Lewis.
Well, Your Honor, listening to this, it might actually make more sense for Dr. Fox to go first. I understand the threshold is low. However, under Rule 702, the argument here is this is not generally accepted in the relevant expert community.
Doesn't need to be, though. That's one of two ways to survive 702B. If it's based upon a scientific method or sufficient education, training, and experience that's reliably applied to sufficient facts and data. But as a blind expert, she doesn't need to apply it at all.
I disagree. There's a case, first of all, yeah, the argument is that under 702. There's a case that is out of the Ninth Circuit that is directly on point and
Is it cited in your brief?
no, because I didn't know about it.
Okay,
It's
can
something
you give
I
it to me?
just discovered.
That's okay.
Anyway, it is United States versus Wells. Let me give you the site. 879 F3rd 900. And that case was also a blind expert who is actually one of Ms. Amon's colleagues in writing the profile for violence. And his name is Dr. I don't know if it's Dr. Reed Malloy is the name of the expert, J.R. Malloy. And there's also, and yeah, I'm sorry, I actually just found this case yesterday. But there's also a 403 and 404B argument because the way this works in courts when they admit profile testimony, which the Ninth Circuit reversed and said this testimony comes in only very, very limited circumstances. They talk about how it's typically used in drug courier cases. This was a case, a homicide case, where Dr. Malloy was using the precursor to the profile for violence. It has very much the same criteria. It has been modified since then. This was in 2017. And he did a profile of killings in the workplace. He was a blind expert, although he admitted on the stand that he had reviewed the case at hand, although he didn't testify. He testified as a blind expert, although he admitted he had reviewed the case and the defendant. And the court ruled that this is improper character evidence, among other problems, because what happens is the profiler testifies that, so people who commit, in this case, workplace murder, have characteristics X, Y, and Z. And then other witnesses get on and say, well, the defendant had characteristic X, Y, and Z. So therefore, in conformity with that character, he committed the murder.
Yeah, but this is different than that. Like I've looked at Ms. Amon's proffer. She doesn't make it that specific. I'm sensitive to that concern. And certainly if she was saying, when we look at domestic violence, homicides, what we see are the following characteristics almost universally. She doesn't do anything like that. There's no level of that kind of specificity. She talks more high level in terms of initial grievance, inability to let it go, form of a plan. I may be missummarizing here, but there's a higher level to it. And when we look at Diaz is even more specific, and somehow a majority of the United States Supreme Court is like, yeah, they said most, not all. So the trier of fact can draw distinctions. How do I apply Diaz to Ms. Amon's testimony to say she can't come in?
I haven't looked at Diaz in a while. I'm sorry.
That is one you cited.
I know it is, and I did not reread that case. So I would actually
We can we'll take a break at some point.
need
We
a
can
moment to
compare.
review that, to be frank.
Okay, Ms. Chervenet.
Oh, I'm sorry.
Oh, okay.
I do think that it would be helpful to hear Dr. Fox's
Sure.
testimony. For one thing, this routinely isn't used. It's used at NBAU as an investigative technique sometimes,
Right.
but it's not used in the courtroom. And that's because of all these problems that Dr. Fox is much more qualified to address than I am in terms of it's junk science is what it is. It's not scientific. It's not used in the community. And I think that does stop it even under our low threshold here.
Well, hold on, but come back to the specific context of this case. The state has noticed Ms. Amon as a potential rebuttal expert, if necessary, to respond to an argument from a defense witness to the effect of, this is not the way it works. This allegation that Kouri Richins killed her husband is not credible because wives don't kill their husbands. People don't just snap and do this. That would seem to make this kind of explanation of how violent crimes are planned and executed helpful to the trier of fact under 702A to say, well, actually, based upon a retrospective study by the FBI Behavioral Science Unit, there is a pathway in which people do this. Full stop. And then the trier of fact can say this is within or without that body of cases. Tell me why that isn't allowable under Utah's Rule 702.
Well,
Now, first of all, if the defense doesn't make such an argument, then the state never calls Ms. Amon.
I think we're going to need some clarification beforehand. If Ms. Richins testifies and testifies that she did not do this,
That denies committing the crime.
the crime, then how does that not open the door for them to say, well, of course she committed the crime because she's on this pathway to violence?
No, I don't think they get to do that. That would be more like profiling.
Okay. I still have the whole 702 problem, no matter how. And this is the first I've heard it's only going to be used in rebuttal. I think we would actually use less time if we let Dr. Fox
Happy to.
go through and explain the problems with the reliability of the science and then go from there, if that's all right.
Sure. Ms. Chervenet.
The only points I wanted to make, and the court has honed in on this, but in Dr. Fox's declaration that was submitted as an attachment, she analyzes the federal rule 702 and why Ms. Amon's proffer does not fit within that. There are fundamental differences between the federal rule and the Utah rule, and I don't believe that it's helpful for the defense's witness to make a legal analysis about whether Ms. Amon's testimony does or does not comport with Rule 702. That is for the court to do. So
I agree, but I can sort that out.
And Dr. Fox is familiar with the Utah Rule 702 and is prepared to address that.
Well, but I don't need her to address the law at all. I just need her to tell me her view.
I understand, but
the
she hasn't
science.
now analyzed it under the Utah
Okay.
law. All right. Would it be all right if we go forward with Dr. Fox?
Sure.
All right.
Dr. Fox, good morning.
Hi, good morning.
Okay. Sounds like you can hear us okay.
I can.
Let me turn on the video in the courtroom so that you can see Ms. Lewis.
Good morning, Dr. Fox.
Hi, Ms. Lewis.
So can you just please state your name for the record and tell us what your current position is?
My name is Dr. Brianna Fox. I'm a tenured full professor in the Department of Criminology at the University of South Florida. I also hold courtesy appointments at the Department of Psychology and Mental Health Law and Policy, both at USF. I'm a faculty affiliate in the Mental Health Institute at USF, and I'm also the co-founder of the USF Center for Justice Research and Policy.
Thank you. And could you, did you want to swear her in? We didn't do that.
Yes, thank you.
Thank
Dr. Fox, would you please raise your right hand for me? Do you swear that the testimony you'll give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
All right, please proceed.
All right. And could you briefly describe your educational background for the court?
Yeah, well, I went to Penn State University. I dual majored in psychology and criminology. I was going to be a pre-law, but I actually changed tax. I went to the University of Florida to earn my master's. And then I earned my PhD instead of my JD from the University of Cambridge in England. My doctoral dissertation specifically evaluated the accuracy and reliability of offender profiling methods, which is obviously related to the issues before this court.
Okay, thank you. And what's your experience with the FBI?
Well, I was an honors intern. That's how I started. I went on to get a position. They asked me to join them in the behavioral science unit as a research fellow. They were actually acutely aware of the problems that they were facing with threat assessment and how inaccurate it is. So that's actually why they brought me on, was to really bring that into the modern era, improve it, use statistics and science, which they were sorely lacking. So that's how I got my start. I worked in the behavioral science unit as a research fellow. I was doing research. I was going over to the BAU. I was training people like Ms. Amon, although I didn't actually work with her specifically, and trying to get them kind of brought up to modern standards. Then I got a position as an FBI special agent. I worked in the Las Vegas division. And in between there, I worked with the Tampa field office in the field of investigations group. I actually still work with the FBI. I just did a project with them out in Sacramento.
Let me ask you just briefly. You talked about that you worked with the BSU, and I know Ms. Amon has talked about the BAU. What's the difference between those two divisions?
Yeah, the BSU was really their research arm. That was where they were really tasked with doing the data analysis, trying to develop the new, latest, and best approaches for investigative techniques. We would then go on to train both people at the National Academy. That's a prestigious group of law enforcement that come in from around the globe. We would train them, so our methods would get disseminated into their investigations around the planet. But then we would also go to BAU. We would take what we were doing, implement it. We were also trying to train them to bring them kind of up to what we were doing over in the research arm. BAU was very operational. We were the research folks.
Okay. And have you published research relevant to offender profiling and violence risk?
Yeah, that's actually the main part of my job. I have more than 50 peer-reviewed articles. I've written 5 books. I have over 3,000 citations. My work has been published in the top journals in psychology, clinical psychology, law, sociology, criminology, developmental psychology. So my goal is to actually try to create more established and evidence-based risk factors, trying to understand the development of offending. Again, this is an area that we are really lacking in, so there's plenty of opportunity for that science and data-driven research.
Okay. And do you have experience in violence risk assessment or threat assessment?
Yes, I do. I have extensive experience in both violence risk assessment and threat assessment through my academic research. Obviously, I also get federal grants. I work a lot with the U.S. National Institute of Justice. I have applied professional experience working with law enforcement agencies. This was mentioned before this, but there is a distinction between investigative efforts and then obviously applied efforts in a legal setting. I would say that my experience as a FBI special agent and of course as a research fellow in the FBI's behavioral science unit, where I evaluated and then tried to help improve the scientific validity of both profiling and threat indicators, is what really has motivated me as a researcher, kind of trying to take that old school approach and modernize it, and really trying to assess the reliability and validity of violence risk assessments, as well as these theories of behavior. That's where I won the early career award in specifically my work on developing theory on why people become offenders.
All right. And you heard us talk in court about the different standards and rules. And have you familiarized yourself with the Utah standard in addition to the federal standard?
Yes, I have read about the Utah Rule of Evidence 702. I have testified as an expert in other cases, so I'm familiar with the federal rules of evidence. And I do understand as well just how to evaluate scientific merit and reliability. I was the editor of our field's premier journal, Justice Quarterly. So as a journal editor, it was my literal task to assess scientific merit and how we can really understand, is this a credible theory? Not every theory gets published just because it is a theory. It really has to meet certain standards.
Is there any objection to certifying that she is an expert in this particular area?
Nobody said she isn't.
Okay, just wanted to make sure as we move forward. All right, so are you familiar with the pathway to violence model?
Yes, I am.
And can you describe what that model proposes, just generally?
Yeah, so the Pathway to Violence model is a group-based descriptive framework. It outlines a sequence or phases of behaviors that are thought of being observed retrospectively among individuals. It's really applied almost exclusively to individuals that commit targeted acts of violence like mass shootings or terrorist attacks. To be clear, it is not a diagnostic tool. It is not a validated risk assessment tool, and it cannot be applied to individual cases. It was not created using data. It has no scientific testing or reliability. It is pure theory, and it was postulated by individuals that, frankly, I don't want this to sound mean, but they have no scientific training.
All right. And is it designed to diagnose or predict whether a specific individual will commit violence?
Again, no. It's a subjective, group-based descriptive framework. At best, it applies only to some cases. I thought the judge's explanation of it was great. It applies sometimes, but in other cases, it doesn't apply. So we really have no idea how often that occurs. It applies sometimes, except for when it doesn't. So it's completely disconnected from data and science.
What's the difference between a descriptive model and a predictive risk assessment?
Well, group-based descriptive models just summarize patterns or characteristics that are observed across groups of people on the average after the events have occurred. That's ones that are created using data. The ones that I'm familiar with, like when I worked in the FBI's behavioral science unit, the infamous, organized, disorganized profiles, they were created just by thinking about what we see sometimes in cases, and sometimes we don't. Those have also been excluded as being admissible for that same reason. That doesn't mean that you can't use them if you want to investigatively, but you can't use that later on in court to say, this person fits this profile. So predictive risk assessments, by contrast, are empirically tested. You want to be able to forecast individual outcomes before they occur. And just, a distinction from the group-based descriptive method, you really have no idea how often it applies or doesn't. Unless there's associated data, you really have no clue how often is it accurate. You can use the words mostly, but it's one person's opinion. There hasn't been a scientific evaluation of this to actually say this often it applies, this often it doesn't. There's no known error rate. There's no accuracy rate. There's no reliability measure. It's just a, guess.
So that's why it's important in a legal framework that the pathway to violence is descriptive framework and not predictive.
Yeah, it's descriptive. It would be like saying that both of us are female, and females are more prone to, I'm trying to even think of an example that wouldn't, that would be kind of as like detached from the data. But we could say, well, both these women would engage in, they're both in a courtroom today, so women tend to be in courtrooms. It's like, well, just because the two people that our judges seeing today both are in a courtroom, that doesn't mean all women are in a courtroom. The example I use in my undergraduate course: every person who went to the moon eats chicken. That doesn't mean that everyone who eats chicken goes to the moon.
All right. So does the pathway to violence, does it tell us how likely it is that someone will engage in violence?
No, that's a major flaw of it. It has no estimates for the likelihood, probability, risk. It doesn't quantify anything. There's no statistical basis behind it. There's no prospective testing, no base rate adjustment, no error rate. All the reliability measures that we would see as scientists, it has none of those.
And can it distinguish between people who commit violence and those who don't commit violence?
No, I think the major, I keep on saying this, another major problem I have with this is there are lots of people that have those grievances. I can name like so many cases off the top of my head that will never go on to commit violence. And we have no idea how often people will follow this pathway and literally never commit violence, or they do some things and then stop and don't commit violence. There's no associated numbers with these. So people who engage in, out of a larger group and engage in similar grievances, thoughts, and behaviors and never engage in violence, we are unaware of. What the pathway to violence model is doing, they're selecting on the dependent variable. They're selecting people that commit violence and say, oh, all those people do this based on, our thoughts. It's not even based on their analysis of data.
All right. So addressing the reliability and the 702 standards, has the pathway to violence been published in peer-reviewed journals?
No, I was actually shocked. I thought I heard somebody say that before this. I trust when I say I've researched this extensively. Book chapters and governmental white papers are not publications. Those are, they don't undergo a peer review process. I've written 5 books, so I'm aware of the process. It's not that. I've also written governmental white papers. There's no peer review process. You could write whatever you want as long as the publisher agrees to print it. You're good to go. In Ms. Amon's proffer, the pathway to violence model was just discussed only one time in a published paper in the Journal of Forensic Sciences. Again, I don't know how to say this without sounding like I'm mean, but that's a predatory journal. They write to me often and ask me if they can publish whatever I want in that journal. It's not like a legitimate, valid journal. And that paper that was published in the Journal of Forensic Sciences, it wasn't even about the pathway to violence model. It was about political assassination in the United States. The pathway to violence model was only mentioned. It wasn't even a study of the pathway to violence model. So it's never been published in a peer-reviewed journal ever to date. And I think that's saying a lot.
When discussing reliability, why is it important? I asked this, I've had battles on this before with experts, but why is it important that it be published in peer review journals as opposed to other journals or just being available?
Yeah, it's not so high of a standard, but that's a standard for a scientific merit and reliability. We don't give things that stamp of approval if it's not reliable and valid. That's not the highest bar in the world. So to say it was never published in a peer-reviewed journal, I really think that's saying a lot.
Okay. Does the pathway to violence have a standardized methodology?
No, and that's actually one of the reasons why it hasn't been published, I would assume, as a journal editor. There's no operating manual. Everybody can, what I determine to be a grievance could be different than what Ms. Amon thinks is a grievance or what you think is a grievance. There's no coding sheets. There's no requirement for evaluators to determine these things using the same criteria. There's no uniform objectivity in this. Everybody can look at it and say that fits, and there's subjective interpretation behind it, meaning evaluators are not constrained to apply the term the same way across different cases.
All right. So different evaluators could look at the exact same fact pattern and come up with opposite conclusions. Is that fair?
Yes, absolutely, because there is no standardized criteria for what these things mean. They're barely even defined because again, there's so little peer-reviewed papers even discussing it, let alone zero on it. They don't even invoke it in peer-reviewed publications. It's sort of constrained to these like side areas. So an example of this would be two evaluators could use the pathway to violence model and can reach opposite conclusions, and there's no way to determine who's correct.
Okay. So is that consistent with things that are admitted as being scientifically reliable?
No, I think it's actually the opposite. Reliability at its core means, the example again I use in my undergraduate course is if you have two people stand on two scales, you would expect that the scales say the same number. That's reliable. If we have somebody stand on two scales at my gym and at my doctor's office and there's two different results, it's literally not reliable. That's the definition of reliability. Or if you stand on the same scale every day and all of a sudden you're getting different results, it could mean that your weight has changed, but if it's 2 times in the same day, probably not. It means your scale is broken. So, this model is broken.
Okay. Is that connected to inter-rater reliability? I know we had discussed that, and I wasn't entirely clear myself on how that is relevant to the acceptable.
Yeah, inter-rater reliability is, again, since reliability is such a key foundational element of what is scientifically valid, inter-rater reliability is basically this idea that if two people use the same construct, will they get the same result? And if people are having the same scale, implementing it and get different answers, it's not reliable. It just has a basic foundational level. So you would want the same instrument applied and to get similar results. So two people should be able to look at the same case and have a general agreement that this person either meets these criteria, they would agree they're both experiencing a grievance. That's something that you would expect. Inter-rater reliability, that's mandated for something to be considered reliable. I would actually argue that this doesn't even have the ability to determine if it's reliable, since there's been no study conducted ever on the inter-rater reliability on the pathway to violence model.
Does it have a known error rate?
No. And that's obviously a problem in terms of false positives. You could say, I think this person, or this is what tends to occur on the majority, that somebody would be on this pathway to violence. You have no idea how often that happens. You have no idea how often you're wrong. You could say that is the case, but we have no idea what percentile of the population actually fits that model, because there is no known error rate.
And why is that a problem for in terms of admissibility?
Yeah, well, without an error rate, the court cannot assess reliability. A method that you can't quantify how often it's wrong if you literally don't have that number. And this has never been studied. It has no data behind it, so you have no idea how often it's incorrect.
Okay, and has the model ever been applied prospectively to identify individuals then who later actually do go on and commit violence?
Never.
All right. Is there any scientific data showing how often? I'm almost done, but I'm sorry, what?
Oh, I didn't say anything. My apologies.
Oh, okay. Is there any scientific data showing how often people identified as being on the pathway then actually never do commit violence?
No, and without overemphasizing this, there is no reliable data on this. And I'm emphasizing it because that was why I was brought into the behavioral science unit. I was the first and only person at the FBI to do research on mass shooters and terrorists on the pathway to violence. That was literally the task I had. I was the person who did it. And this was in 2000. The first time I started on it was 2010. And then the process of getting access to data was, as you can imagine, quite difficult. I was going through all of it. I was trying to code it. I was the first person to do it. No one had done it before. There was no study ever on this. And what I've been finding, I didn't have the resources to really complete this in the way it should have been done. And it was never published. So that's why I'm also quite sure there's no publications on it. But it really was so much more complicated than what the pathway to violence model suggests. That's such an oversimplification, and it's so inapplicable in so many circumstances. And like I said, there's no known error rate. So we know it's wrong, we just don't know how wrong it is.
So what data was it developed from, the model?
The pathway to violence model, or what I was doing?
The pathway to violence model.
Oh, it's not based on any data. It's based on, like I teach a forensic psychology course. And so there's a great line. I really respect the original profilers. What they did was, groundbreaking back in the 1970s, right? But obviously a lot has happened since 1977. What we've expected, in court, DNA, our standards for what we admit into court has changed a lot. But back then, 1977, when they were developing this, that was what they thought was best. And they developed it off of what they called intuition, educated guesswork, and hunches. And so I always teach my students, like, that was the 70s way, but we're doing this differently now. And the pathways to violence model was developed in that same approach. Educated guesses.
Okay. So Ms. Amon, and I suppose others who've worked on the model, believe that it can be applied after an offense has occurred. And is it scientifically valid after offense has occurred to then go back and use the pathway of violence model?
No, I mean, that's like a basic logical fallacy. That was probably on your LSAT exam, that you can't do that. Applying a descriptive model retrospectively to infer that the person therefore fits it is like predicting the lottery numbers after the drawing already occurred. I don't know. I don't know how to describe this another way. It just doesn't make logical sense. It is a logical fallacy to do so.
Well, in fact, an example of that fallacy is the 9/11 attacks. Is that right?
Yes, that actually, there's the pathways to radicalization. We've, toyed around with this idea. They've all been kicked around and kicked down. But that one was the pathways to radicalization profile. And it was this like traits shared by attackers. They're young, male, Middle Eastern, and you could say, looking at, the 9/11 attacks, yeah, they all fit that profile. But when you apply it retrospectively, there's 55 million, right, plus people that fit that are young Middle Eastern males. Like literally it goes down from, everybody who, commits terrorist attacks fit this profile to 0.00000, like I don't even know how many digits out, 0%. It's basically 0%. It doesn't fit at all. There's no validity. There's so many people that fit that profile and never go on to commit a terrorist attack. So what's the actual value of saying this is a pathway to radicalization? There's so many people that would fit that and never go on to commit the act. Cherry picking after the fact and saying, all the people fit that. Not only is that a logical fallacy, I would actually say that's, it could be a violation of people's rights, to be able to make that implication of them just without even having 1% accuracy rate.
So how does that relate to the pathway to violence model?
The pathway to violence suffers the same fatal flaw. By implying these group level descriptives, you're first of all applying it, and we have no idea. It could apply to 1% of people that have a grievance. They, go to a workplace nowadays, right? So many people have grievances. So many people are upset. They're feeling stressed by the economy, by their situation. They even may say, "I'm so stressed, I'm mad." They will never go on to commit violence. This is an extremely rare base rate event. And low base rate events have very high risk of false positives. And when you are now going to take that and enter it in as an expert opinion, obviously, just me as a scientist, as somebody who supports the research in this area, and of course, like as an American taxpayer, I feel very concerned by that.
So let me ask you, you heard the discussion before you testified about if Ms. Amon were to testify in rebuttal, that why someone who is a mother or someone who is in the position of Ms. Richins might commit this offense because of being on this pathway to violence. In your expert opinion, is that helpful to a jury, and why is that problematic?
Yeah, I actually think that the risks are so far beyond the benefits. I mean, there's so many people that experience grievances, anger, even violent ideations. There are a lot of studies on that. So there's plenty of research that can be discussed to talk about the base rate of those. They're high, but then when you look at the predictive ability, how often do they go on to predict violence? Extremely low. The reason is because if we were that good at predicting violence, I mean, think about the problems we have when we're talking about parole. We're talking about risk assessment when we're looking at releasing people. We're doing my big NIJ grant was specifically to do risk assessment to try to identify people who are low, medium, and high risk. This is such a big area because we are so bad at it, even with huge amounts of data, huge amounts of research behind us. There's no way that something like this is able to be better than all of the research and data that we have based on hunches. Our data suggests that things like grievances, feeling anger, violent ideation, they have such a low predictive ability to actually accurately predict violent behavior because violence is a low base rate phenomenon. Lots of people have these types of feelings. Very few ever go on to commit violence. Even if you fit all of them, you literally have a low probability of actually committing violence. I could actually, look that up in a couple of minutes and tell you what the base rate is. But because this pathway to violence model has never been evaluated, anyone who would say, here's what I think, they're just guessing how often someone would actually go on to commit violence.
Let me ask you, tell me if I'm wrong. When I was looking at the pathway to violence, it appeared that the purpose of it was to try and help identify mass shooters, school shooters. Why has this been put together? For what purpose if it doesn't actually ever predict who will go forward to commit a violent act?
I'm telling you guys, if we were able to predict with any level of accuracy who was going to become a school shooter or a mass shooter, I mean, we would have a much better situation in our world right now. Again, even with accurate data, like we're collecting, looking at this, putting very sophisticated predictive models together, we are so unable to predict the violence, school violence, these targeted violence offenses, and domestic violence is even harder to predict. As our judge mentioned earlier, the vast majority of them are emotional. They're not these, long premeditated, thought out things. So the emotional dynamic factors actually have a much higher predictive validity than any type of long-term grievance, at least based on research. If we were able to do this, I would feel much better about my young son, going to school soon. I'm terrified because we are so bad at it. Even from a magnet, huge amounts of money being spent on this type of research, we are still unable to do it with any type of reasonable accuracy because finding that needle in a haystack, someone who meets all of these criteria but is actually going to commit violence, is so hard to do.
Let me ask you, just for sake of argument, if we were to assume that the pathway for violence had some reliability in the area of mass shooting and school shooting, was it meant to be applied in this sort of case?
Oh, no. And that's actually, again, something I talk about in my undergraduate courses. We have this problem, it's like mission creep. We think, because it applies here, it can apply over here. And that's absolutely not the case. A domestic violence type of scenario, poisoning, they're so fundamentally different in the way those two things are committed, played out. Applying something that is, even without data, created for the purposes of these targeted attacks that do engage in more radicalization behaviors. You applying that to something that's statistically more emotionally driven, that would be very inappropriate.
All right. So just to wrap up, in your expert opinion, should the pathway to violence be admitted as scientifically reliable evidence that a jury can rely on?
No, absolutely not. If we're basing this on reliability, if we're basing it on, how using it to know that this is scientifically valid. Absolutely not. The logical fallacies that are endemic to this, the huge amounts of unknowns, like how often it's wrong, which would be far more wrong than right. It's akin to like the Barnum effect at circuses, or like psychics. That would be the closest, I would say, in terms of how accurate and valid and applicable this would be to an individual case.
I have nothing further.
Ms. Shervnak, do you have any questions for Ms. Fox?
I do.
Ms. Fox, may I ask you just a couple of basic questions?
Surely.
You went through the FBI Academy at Quantico.
Yes, I did.
Were the pathways to violence taught as part of that curriculum?
No, it wasn't.
Did you have exposure to this during your career in the FBI?
No, I wasn't. There are these, similar models, like, I think they call it like pathways to radicalization. And I just learned about that. And again, like while I was in the BSU, that was one of the things that I was brought on to try to revamp and improve.
Okay, thank you. Ms. Lewis, anything further?
No, Your Honor.
Okay. Ms. Shervnak, anything for Dr. Fox? Okay. Thank you, Dr. Fox. You're welcome to stay connected, but you're also welcome to turn off your video and audio.
Thank you.
Ms. Lewis, do you want to ask any questions of Ms. Amon?
Are you not going to put Ms. Amon? Is the state going to put Ms. Amon on, or only if I have questions? I guess would be
Ms.
my.
Shervnak, are you relying on her proffer, or do you want to elicit some testimony from her?
I'll elicit some testimony from
Okay. Ms. Amon, do you mind turning on your video and audio? May I swear you in, please? Do you swear that the testimony you give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
All right.
Good morning, Ms. Amon.
Good morning.
Your Honor, before I begin with her testimony, Ms. Amon's CV lays out her qualifications. The state's position is that she possesses the requisite knowledge, training, experience, education to satisfy 702A. If the court sees it differently, I'm happy to ask her some of those questions, but I prefer to focus my questions directly elsewhere. If that
I
makes sense.
agree that her CV reflects that she has sufficient education, training, and experience to qualify under 702A as an expert in her field.
Thank you, Your Honor. So, Ms. Amon, I don't think we need to go through all of the steps of the pathway to violence. I think the court has the generalized view of it, but what I would like to ask you are a few questions about how this model was developed, and we'll start there.
Sure. So in terms of how the model was developed, you'd have to, I guess, go back. The scientific research leading up to where we are now started about 100 years ago, give or take, when researchers began studying aggression in mammals. Specifically, cats were the sort of the origin story of this line of research. And researchers noticed two distinct patterns of aggression in cats, depending on the circumstances. In some studies, cats were presented with a threatening stimulus, a very threatening stimulus. And in those cases, they demonstrated intense autonomic arousal. So arched back, fluffed tail, hair along the midline, standing on end, that's called piloerection, pinned back ears. They vocalized, such as hissing and growling, fangs out, claws bared, the whole show. You can sort of think of it as that classic Halloween decoration of the scaredy cat with the arched back and all that. And they very quickly lashed out with an emotionally charged and relatively uncontrolled attack with paws and claws. And that was labeled affective violence. It's affective for the psychological term affect, meaning sort of the state of thinking or emoting or feeling emotions. And then in other studies, the cats were presented with prey, like a mouse. And that was a totally different story. The cats were low to the ground, completely silent. Ears, instead of pinned back, they were open to localize sound, and the cats would inch forward, and they appeared to be planning and carrying out an attack at the moment of their choosing, typically with a bite to the neck or head, a very efficient biting attack that ended the fight really before it began. And over the next several decades, that line of research expanded to other mammals, including humans. And what they discovered was that not only do these behavioral patterns hold true in humans, but they're also biologically distinct from one another. And the understanding came now that affective violence, so that reactive attack, is triggered by lower brain structures in the limbic system, triggering an intense autonomic arousal, as I've discussed, usually accompanied by intense fear or anger, and a cascade of hormones, all culminating in a sudden physical defense against imminent threat, which could be real or perceived. It could be an internalized threat. And the evolutionary basis for that in humans is survival. So if you were an early human out on the savannah, there was really no time to ponder whether that movement in the bush was caused by the wind or a predator. The early humans who acted quickly were the ones who survived. In terms of predatory violence, we now understand that to be characterized by a lack of autonomic arousal or emotional experience and no perception of a threat. And that lack of stimulation allows for higher cortical activity in the brain to choreograph an attack that meets the attacker's goals, whatever those goals may be. And the evolutionary basis for that in humans is hunting for food. So early humans on the savannah who hunted with minimal autonomic arousal, no anger or fear, were better able to engage higher brain functions to plan and prepare in advance, and therefore were likely to return with food for their offspring. Those who could not or did not do that were less likely to survive and pass on their genes. And we know that humans, like none of us would be here right now if our ancestors didn't have the capacity for both of those types of violence. So fast forward to now, there have been studies on neurochemicals and hormones, neuroanatomical brain scans with PET and MRI, to look at the differences between these two modes of violence, and all of them support the bimodal nature of violence. So that research evolved more or less concurrently with behavioral studies that were going on in the 80s and 90s on attacks against celebrities, judges, governmental figures, and some others, all of which led to a very clear conclusion that intended violence is a process composed of discrete, sequential, and recognizable behaviors. And the pathway to violence model came into being at the conclusion of that time frame based on the biological data and the behavioral observation data from all of the studies, many studies. So that's kind of a 10,000-foot view of the science in terms of how we got to where we are now.
So how is the pathway to violence used in the behavioral analysis community?
We use it not to predict, but to prevent. And that's a very clear distinction that needs to be made. Prediction is not possible. We don't talk about predicting human behavior. We talk about preventing it. I would liken it to if, let's say, I'm your cardiologist and you came to me and you were very overweight, sedentary, hypertensive, you had high serum cholesterol, you had bacon for every meal, and you were super stressed out. As your cardiologist, I couldn't tell you that you're going to have a heart attack next Tuesday morning at 9:24 a.m. But what I can tell you is that you're at heightened risk for a cardiac event, and we need to manage your condition with lifestyle changes and probably some medication to lower that risk. That's how we work in behavioral threat assessment, and the pathway is part of that. It's only applied in cases where where someone has already presented themselves to authorities, to whoever, as raising concerns for violence. So the person is doing something that has brought concerns of violence to the table. Whoever's bringing us the case, maybe it's a school district, maybe it's a workplace, isn't sure what to do. We would begin to look at the behaviors the person is demonstrating, and our being on the lookout for possible pathway behaviors is one of the things that we would do. It's actually considered one of one of 8 proximal warning behaviors that we would look at to decide if this person needs a deeper look. So it's a tool. It's one of many tools we use. It's certainly been subject of many studies in terms of whether or not it's valid for measuring what we want to measure. That is, behaviors that raise for us concern about whether or not violence might be on the horizon.
And is the pathway to violence utilized, or could it be utilized in instances of targeted violence that only include one individual as the target?
Oh, certainly. Targeted violence is targeted violence. They all share behavioral commonalities, particularly where the pathway is concerned. If you understand the nature of the path, the items on the pathway, then you also understand that the majority of them are steps that most targeted violence offenders would pass through. Whether you're planning to kill 100 people or one person, you still have to make the decision to do it. You still have to engage in some planning, some preparation, even if it's very, very simple. Some people require a lot of planning and preparation. Some people require very little to get to a state of readiness. But it doesn't really matter what the size of the targeting is. That's not relevant. What's relevant is that certain behaviors must occur in most cases in order to get someone to a state of readiness to engage in planned violence. I'm not talking about unplanned violence or affective violence. That's not really relevant here. But most people will have to pass through some of those stages, if not all.
Is the pathway to violence model generally accepted in the behavioral analysis or behavioral science community?
Absolutely. It's completely foundational to what we do. I know of no learned and credible threat assessment professionals who don't believe in the pathway. It's at the foundation of what we do. It's included in virtually every aspect of what we consider the body of knowledge in behavioral threat assessment, which I used to administer. I'm a former chair of this national certification program in this discipline, and the pathway is very foundational.
And is that something that you would describe as currently used, or is this a past a model that was used in the past, or is it a currently used model?
Currently used. Up until about 2012 or so, it was kind of it was the name of the game. It was the pathway. And then right around 2012, we had the realization that it's but one of 8 proximal warning behaviors, proximal meaning close in time to a potential act of violence. And so now we tend to look at pathway as one of those 8. So in terms of more recent studies, in terms of its validation, it's the proximal warning behaviors that we look at. We don't usually use the word pathway necessarily on its own, but it is a discrete behavior as part of the 8 proximal warning behaviors. But it's absolutely used now. It's very, very important to what we do.
And now, if you could explain the retrospective analysis and why prospective analysis is not feasible.
Sure. All the studies on pathway and proximal warning behaviors are retrospective. And in fact, someone asked me at a conference the other day, where are we on prospective research? And my answer was nowhere. We can't do it. So retrospective analysis is looking backward at cases with a known result. So violence. So let's say I want to look at a single person homicide in a workplace. I would look backwards at the completed event, knowing that it had the result that I'm interested in, violence. And then I would look for what patterns of behavior can I identify that did occur leading up to the violent event, and then code those. And so I would know that those occurred. So a retrospective study would have a sample of cases and then look backward in time and code the behaviors that we know to have occurred. And that helps us to understand what are the commonalities. You can't, Dr. Fox is absolutely correct that those studies can't be used for prediction. They're not predictive validity studies, but what they do is validate the measure as measuring what we intended to measure. Prospective is, you would need a prospective study to truly call something predictive, but to do a prospective study in violence would be to have a case of concern, and then look for what you believe to be pathway behaviors. And once you've identified them, it would require you to sit back and do nothing and allow violence to unfold and then code your data, which is horrible to even think about. None of us would ever do that. So we use retrospective analysis, and it's widely acceptable in the behavioral sciences as a research strategy.
Thank you. Just a moment. Those are my questions for you at the moment. Thank you, Ms. Annan.
Just a moment. Good morning, Ms. Amon.
Good morning.
So, Ms. Shermanek asked you how the model was developed. And you told us about cat research, but I didn't hear an answer as to how the model was actually developed.
Sure. So in the 80s or 90s, a number of studies were conducted on attacks against public figures, political figures, judges, other people. And in those studies, it became quite clear that the offenders were typically engaging in a sequential and recognizable cascade of behaviors leading to the violent attack. And so that became the pathway to violence. The data collected from those studies showed that 6 particular discrete stages were happening in virtually every case that was studied back at that time. And so that became the pathway to violence. Does that answer your question?
A little bit. So, but the pathway to violence talks about, strike that. Let me rephrase. So you used the analogy of a cardiologist. You said this isn't predictive, it's preventive.
Right.
Right?
Right.
So this only applies after an event has happened?
No, not at all. That's how we have studied it. How we use it is in advance. So let's say, for example, you are a school principal and a child in your school has risen to your attention as raising concerns for violence for whatever reason. Maybe he's got a hit list, maybe he's stalking his girlfriend. So I would look at that if I were consulting with you, and I would ask for everything you know about the situation and the child. And I would look for evidence of these 8 proximal warning behaviors primarily that we know to be well correlated with subsequent violence, including the pathway. And if I saw evidence of any of those, then I would advocate for active management of the case to try to reduce the violence risk. The general rule is that once you observe 1 or more of the proximal warning behaviors, then some sort of active management is necessary to prevent violence. So we're managing behaviors of concern in the present to prevent violence in the future. We don't know that the child is ever going to be violent, but we're not waiting around to find out. We're going to take active steps to try to prevent and manage.
And you have no idea if absent those active steps, would that child ever have committed violence, true?
No idea is a bit strong, but do we know? No, we don't know. That's correct. Someone can certainly ride the pathway all the way up to one of the upper steps and then never do a thing. That's entirely possible.
All right. So you talked about that it has been subject to many studies. Could you tell me what studies this has been subject to?
Sure. I was a little bit surprised to hear Dr. Fox say that it has been subject to no studies. The most recent study that was specifically on the pathway and only pathway came out in 2024 in the Journal of Threat Assessment and Management. And they had a very high, actually high inter-rater reliability score in that study. I would say the majority of studies in the last decade are more on proximal warning behaviors is the label that you would have to search by rather than pathway. They're on, almost more than I can count. Public figures, mass attackers, intimate partner homicide offenders, other sorts of family offenders like paternal filicide, maternal filicide, that kind of thing. Workplace, classroom. The journals are really littered with studies looking at proximal warning behaviors.
Are there any peer review studies that you can point to that adopt this?
All peer reviewed studies, all of them.
What are they?
Well, I supplied a list to Ms. Chevernak when they first contacted me, but the most recent one that I mentioned in 2024 is called "Are All Pathway Behaviors Observable? A Quantitative Analysis of the Pathway to Intended Violence Model." And that came out in the Journal of Threat Assessment and Management.
So the same one you just told me about?
Yes.
Okay. All right, so it's not a predictive model, it's a preventive model.
Right.
It's not capable, you can't generate any numerical score, correct?
No.
Using this. And it's not designed to determine if a specific individual is going to commit violence, correct?
No, I agree with Dr. Fox's description that it's a descriptive model. It describes behaviors that have been observed in studies. I would say its operational use is not in prediction, but in prevention, which I think is really a key difference in terms of how we use it in the field.
So it could be useful if someone came to the FBI and said they're thinking about a mass shooting.
I'm not sure I take your meaning.
Well, if it's not useful in predicting violence, and it's useful, as you said in your cardiology example, if someone comes in and says, hey, I'm having these symptoms, then, you can help prevent it. So how is this at all useful in the real world? Because people don't come into the FBI and say, I'm having these symptoms. And you can say, well, you are on the pathway to violence. Let me help you. That doesn't happen, correct?
Yeah, that's never happened as far as I know. But how it is used is if I'm looking at a case where someone has already risen to the attention of whoever is observing as someone being of concern for violence, maybe they've been making threats, maybe they've been menacing people, maybe they have a hit list. I mean, whatever. That can look a million different ways. Then I look at the entirety of the case, as many facts as can be gathered, and then I begin looking for signs of proximal warning behaviors to decide if we're in, sort of an imminent countdown potentially to an act of violence. And that's where the pathway to violence becomes quite useful. If I observe someone on the pathway, particularly in late stage pathway markers, then I might develop, depending on the context, I'd have a lot of questions, but I might become very concerned that we're close to a potential act of violence.
Has this ever actually happened in the real world?
The
Where
way I
you
just
have
described it?
stopped violence based on something that was brought to your attention?
Well,
How can you
we've
say
had
that has happened?
We can't. That's what I mean by there's no prediction. I can't. So when we see pathway behaviors or other proximal warning behaviors, we intervene. That's our job, is to intervene. So once we've intervened and there's no violence, how can we ever say that there would have been violence but for intervention? You can't. You can't prove what never happened.
All right. It's fair to say that two evaluators could look at an individual and reach completely different conclusions, whether someone's on the pathway to violence or not, right?
Not well-trained evaluators.
So your testimony is that people always come to the same conclusion if they're trained in this?
No.
Okay. So people can come to different conclusions, even if they're both well-trained people?
I think if they're well-trained, they should not come to different conclusions on something as fundamental as the pathway.
But
You
it's-
can come to different conclusions about how close someone is to violence.
But it's subjective, right? It's not based on scientific data.
Well, it is based on scientific data. All those studies that I referenced in the 80s and 90s that helped Brian Foskule, Randy Vorum, and Robert Fine arrive at the pathway to violence. That's data.
The journal we talked about that it was published in.
No, that's a different journal. There are dozens of studies, but we're talking about the study I referred you to was in 2024,
Okay.
just because it's the most recent one, specifically on the pathway and only the pathway. But the journals I'm talking about we're talking like 80s and 90s.
There's no way that the model can tell us how often it produces false positives, right?
Correct.
And you can't tell us the model's error rate. True?
Correct.
You can't quantify the likelihood that an individual identified as being on the pathway will not commit violence.
I can't quantify whether they will or will not. It doesn't work that way.
Yet you believe you could apply this framework in this case.
I don't know anything about this case, actually.
Well, you know what the defendant's charged with.
I believe it's a homicide, but I don't know any facts and circumstances or if there are other charges.
Okay. Are you familiar with the case United States versus Wells?
I am not.
Isn't Agent Malloy a colleague of yours who helped write the Pathway to Violence?
Agent Malloy? Oh, Dr. Reed Malloy?
Yes.
He's not an agent. He didn't write the Pathway to Violence, nor did I.
So you're not aware, you gave the example of workplace shooting.
Okay.
So you're not aware that that is the exact case that was rejected as the science being unreliable in the United States versus Wells. You're not aware of that.
I'm sorry. I have no idea what you're talking about.
All right. Have you testified in a homicide trial about the Pathway to Violence previously?
I have not.
Have you testified as an expert previously?
I have not.
Can you give me any examples where the pathway to violence was used in the courtroom at a homicide trial after the fact?
I don't know.
Okay, I have nothing further.
Ms. Shervanack, anything further?
No.
Okay. Ms. Ammon, thank you. You're welcome to turn off your video and your camera. Why don't we take a 10-minute break and then we'll come back. Thank you. Come back at 11:10. Thank you. Court's in recess. Manuel.
We don't have no TiVo time. I wish we had some TiVo time, but we don't have no TiVo time, guys. I don't know what to tell you. Yeah, no TiVo time. I know that our next court hearing for our officer that's on trial, that does start at 12. That's why I was asking y'all, were y'all bored? Because I was gonna start it at 12:30, but I think that we'll go over there exactly on time to see, is this trial gonna continue? Are we gonna have a mistrial, or what is going on? You said, where the fork is everyone today? I don't know. I don't know. Maybe working. You know, we got a lot of habitual cheaters over here, drunkie. They be treat me like a side chick, drunkie. I'm so glad you don't treat me like a side chick. But I got some habitual cheaters. Thank you. I had it up in a ponytail and when we first started, and my hairpin was bothering me. I had to take it out. You say they watching Reiner? Yeah, that could be true too. Yeah, and I don't know. I'm ready to kind of get back into our school case. Because I want to see exactly what this judge is going to decide, and more importantly, what is he going to decide? Because remember, guys, we have a Brady violation going on here. Okay, you only cheat for Sarah Boone content? Okay. Shoot. Well, you won't cheat that often because I don't think she got nothing going on. But tell us the next person to get in the suitcase. That ding dong. You know, for the life of me, I cannot believe that she knew. I mean, because she knows if she was guilty, right? I don't know why she just didn't take the 15 years, man. So they do have a courtroom live feed up, but like I said, I know that law and crime, they do open their rooms up pretty early just to kind of get everybody in there so everybody can get a seat, get their popcorn, get ready. So we won't go over there just yet. I'm here listening on TV while I search for a hotel to go see my daughter. What you say? You here? Yeah, Liz. Like she knew she was guilty. Yeah, I think that's the other thing is that YouTube, when it don't see us like in the chat, it's something new with YouTube. I'm telling you. Now it don't really even count lurkers. So lurkers have to check in. Or what it do is it make the number go down. Like on how many people are here. So and it don't even really it's really bad for like little small channels like me, like us over here, because shoot, I need the 3 lurkers that's sitting over there, and they like, no, we not counting these 3 lurkers. So instead of it looking like it's 11 people in the chat, it go down to 6. And let's see here. Yeah, and I don't even y'all know anything about this Michelle lady? Something where she going up for appeal. Do y'all know anything about that case? I haven't heard of it. Something where she going for an appeal, but I don't know what the appeal is for. Yeah, I did. I think that it just depends on I haven't figured it out. I really haven't figured it out. It's like sometimes YouTube really, really, really likes me, and then sometimes I don't think it does. So it's like sometimes I feel like a nut, sometimes I don't. Enjoy's got nuts, mounds don't. No, I didn't. No, Marilda. Nope. I think this is what I think what we'll do is I don't know if I really have to listen to any more of this Kouri stuff today. Like I don't know what they talking about. It sounds like womp womp womp. I don't care who testify. Just get the testimony or whatever y'all need in. I thought it was gonna be something more exciting than that. But what I am ready to get into is I'm trying to see these arguments in regards to what do the defense want from this Brady violation? It's not often we have this, but when we do, So what I want to,
area where we see this happening. But it wasn't
I am
an
going
expert
to go
witness,
into
exactly. It was a
our,
detective who was
I'm gonna
testifying
go
based
in
upon
here and get
experience.
our
And
room
based on his experience,
link for
he
our
said
new trial
that
because
in,
I
you know,
want to
all
keep it
his years
separate
as
from this
being,
this
whatever kind of
over
agent he
here.
was in drug cases,
Um,
he always saw
in
the
all
same
which
profile
ways.
of drug couriers.
So I
He
am
said
going to
most,
go
didn't he?
over
Isn't
here
that the
to
distinction?
set up
It might have
our,
been, I don't know if it was all or most. It was most all.
Key part of the case is that he
open
said
up our
most,
room.
and that's how Justice Thomas said, well, that's not impermissible under 704B because it acknowledges that there are some outside of most
Okay.
who don't.
Either way, it's different because he was an experienced witness, not an expert witness. And in this case,
Because I do have a
is
video
not
that I want to
an
play.
experienced witness. She
His
didn't
attorneys
write
spoke this
She hasn't
morning,
done.
and I
She
do want
can't
to
get up
listen
there
to
and
it.
say what the detective said in that case
So let me
because for a number of reasons.
let me get that
Other
room,
people
and
did
I am
say-
going to send that
May
to
I
you
cut
guys
the
so we
chase a
can
little
go
bit
over
here?
there and
See if we
watch.
see it the same way. I agree.
We can watch that,
with
and
the
then we can go
defense
into that
under
trial.
cases like
What
United
is playing
States
in the
versus
background?
Wells.
I don't have anything playing in the background. You hear something?
Testimony that
Let
Ms.
me- oh.
Heyman offers
Oh.
cannot be used in the state's case
I got
in
it
chief
mute.
and cannot be used in any part of the case as substantive.
Oh, that's back to Kouri Richardson. I guess they back. Sorry. Oh, it looked like the judge is ruling, so maybe we should listen to this. Listen. Sorry.
Right.
Area where we see this happening. But it wasn't an expert witness exactly. It was a detective who was testifying based upon experience. And based on his experience, he said that in, you know, all his years as being whatever kind of agent he was in drug cases, he always saw this same profile of drug couriers.
I think he said most, didn't he? Isn't that the distinction?
It might have been, I don't know if it was all or most. It was most all.
Key part of the case is that he said most, and that's how Justice Thomas said, well, that's not impermissible under 704B because it acknowledges that there are some.
Experienced witness. She didn't write this. She hasn't done. She can't get up there and say what the detective said in that case because for a number of reasons. Other people did the studies.
May I cut to the chase a little bit here to
Sure.
see if we see it the same way? I agree with the defense that under cases like United States versus Wells, the expert testimony that Ms. Heyman offers cannot be used in the state's case in chief and cannot be used in any part of the case as substantive evidence of defendant's guilt. Here, though, the issue, based on the briefing, is more nuanced. It seems to me that the state could use Ms. Heyman's expert testimony in its rebuttal case and only to rebut a general categorical assertion by the defendant in her defense case that this is simply not how it works. This is not credible that someone would engage in a weeks-long campaign to kill someone in the absence of an imminent threat to their life or some kind of emotional or extreme impetus. If there's that kind of categorical, generalized argument made by the defense, then I think this testimony from Ms. Heyman, which is based upon a retrospective study of killings that actually occurred, saying in the retrospective study of killings that actually occurred, people did plan them over a varying level of time, and there were steps they took along the way. As long as the prosecution did not turn the corner in closing argument to say, well, we've showed you elements of plan and preparation on behalf of Ms. Richins. You heard Ms. Heyman, so that shows it's more likely than not that Ms. Richins killed her husband. They can't do that in closing. That would be using an inappropriate profile-like argument. But to rebut a categorical generalized statement from the defense that this is simply not the way homicide works, I think that would be helpful to the trier of fact under 702A. Tell me why not.
Well, first of all, this would be the first time that it's ever used that way. You heard Ms. Amon, this has never been used.
Well, that may be because it'd be the first time that a defense ever made that kind of argument, but I'm not sure we're going to have to cross that bridge here.
Well, we may not, but I think it's never been used because it's not reliable. The study wasn't made even though to pick out individuals who commit violence. It was developed, she said, the only time.
But they're not using it predictive in my hypothetical. They're only using it to rebut a generalized statement of murders don't get planned like this.
Well, it can't be used predictive. I think that was pretty clear.
Right,
It's
I'm agreeing
not.
with you on that. We're past that.
All right. So my point is that when she talked about individuals, though, she talked about how the study applied to assassinations. The study was not developed in any way, shape, or form to look at this sort of instance.
Let's be careful here. I think there's a side of the V that would call this an assassination of a non-political figure, but nonetheless, stay focused with me. Why wouldn't that be helpful to the trier of fact under 702A to understand sometimes killings are targeted? We know because we've studied killings that have actually occurred. Sometimes they're planned. Sometimes they take time for that plan to develop.
I guess I don't understand how that's helpful. Yes, isn't that general knowledge that sometimes killings are planned? I don't understand.
I don't know if it is or not, but it's that would be like if the defense is going to make the argument, these things are never planned. This is simply not the way it works. Now, I don't know if you're going to make that argument, but you're asking me to exclude Ms. Amon under any circumstance, and I'm not sure you've carried that water.
Well, we're asking that she be excluded because it's under I'm going to move also under 403 and 404B. It's highly prejudicial for someone to get up there and tell a jury, I'm an expert, and it's if we were to make that argument, which I don't know. Let's see, we were to make the argument. She's a mother. She wouldn't have killed the father of her children. How prejudicial is it for someone to get up who claims they're an expert, who's not an expert, never has testified, never has used the study in this way, and then tell a jury why we're wrong?
You changed my hypothetical. Ms. Amon doesn't comment in any way on the specifics of one mother killing her husband or the father of her children. I'm not suggesting you can't make the argument that Kouri Richins had so much to lose by doing this, it reduces the likelihood that she did it.
But that opens the door for Ms. Amon to come in under your hypothetical
No,
to
it
say,
does not.
no, that could happen.
Please stay focused.
Okay.
A general, absolute, categorical statement by defendant. Murder doesn't happen this way. They're always emotional. They're always in response to a threat. They're always as part of a fight or as part of a criminal enterprise. I don't know what you'd say, but if you want me to exclude her entirely, I'd have to say that there is no set of circumstances in this case under which her testimony would be helpful to the trier of fact, and you haven't carried that burden.
So you're saying that, in your view, the only way her testimony could be relevant is if the defense says this kind of murder would only happen in an enraged, emotional state.
Yeah, or in response to a threat.
Or in response to a threat. That's the
Right.
only way this is coming in.
Right. That seems to be correct. Tell me why that isn't correct.
Well, I don't know that we really even have a problem if that's the court's ruling, that it's only coming in under one specific circumstance. I just think our general objection, though, is that it's just not reliable under 702 under any circumstance. It doesn't matter what the circumstance is. I think that
This is why I'm not persuaded by that. The defense keeps, at least implicitly, taking the position that if two people could apply this framework and reach different conclusions, it's not scientific, it's not reliable. Is that one of the defense arguments?
well, one of many.
Sure.
It's not.
Now, That would mean that every physician that testifies in a medical malpractice case is unreliable, because in every single medical malpractice case, there are competing expert testimonies regarding the standard of care and whether it was breached.
Well-
And they're both admissible, and it all goes to weight, not admissibility.
I thought about that as I was listening to her testimony. And I think the difference is, and I don't do medical malpractice, but I think the difference is when we have competing medical experts, it's typically based on actual scientific research and knowledge. And
Or
they
their
might have
education,
different,
training, and experience. They're not citing studies most of the time.
but it's based in science. You can get two experts who have a different opinion when they apply the science, but this isn't any applied science of any kind. This is just a completely subjective theory.
But the law enforcement expert in Diaz wasn't applying science either, but he was offering specialized education, training, and experience. That's the subject of Rule 702.
Well, he was not an expert, that's true, but he was
In
applying.
Utah, he would have to be qualified as one in order to say what he said.
I know we see that in federal court all the time. They're applying their own experience. I am a DEA agent. I have arrested 1,000 drug couriers. Of those 1,000, the vast majority fit these characteristics. That's very different than what Ms. Amon wants to testify to. It's very different.
I think the rigor of Ms. Amon's testimony is greater in terms of, here are the studies. We looked at killings that actually occurred, identified these factors. We've published it. We've added it to the model. This is how we use it, full stop.
But none of those studies, well, first of all, she really didn't tell us what any of those studies were, but
This goes to weight, and Dr. Fox will be able to tell the jury why this isn't going to help you make these decisions.
that's correct. But if none of the studies have to do with the domestic violence case, how is that helpful to the trier of fact?
Because if you're going to make a categorical people don't murder people this way statement, it has nothing to do with domestic violence anyways.
And I think one of the other problems is when she stated you can go all the way down the pathway of violence and then they don't commit a murder. So how is that even helpful?
That increases the reliability of her testimony instead of decreasing it, because it acknowledges that there are people on the pathway that fall off. So it's a most, not all, a la Diaz.
Okay.
You're going to want the last word, because I think
All right,
it's going
I'm
to
good,
quibble
yes.
with my ruling here. Ms. Shervanek.
Your Honor, I don't know that I have much to add. I think that the type of testimony that Ms. Amon would offer fits squarely within 702. She has specialized knowledge that would assist the trier of fact in making a fact of consequence more or less likely, and that they, being the jury, could use the analytical framework of the pathway to violence, taking the facts that they've heard presented or theories that they've heard presented through witnesses, and applying them to a framework that Ms. Amon lays out to understand how a person in a position commits a murder under certain circumstances. That testimony assists the jury in understanding how this case could play out, how it explains a theory or rebuts the theory put forth by the defendant about how this murder was committed and why it was committed. And the jury can use the framework that she presents or wholly discount it if they find it doesn't apply. And that would be up to the jury to decide. But given the type of testimony that Ms. Amon proffered and that we expect her to present as a rebuttal witness, it fits solely within 702. And for those reasons, it's admissible.
Okay, I understand the state's position. Ms. Lewis, anything further?
I guess my last word is just that under 702, I don't see any scenario under which this is a reliable science that could be presented to the jury. And I also don't think the testimony was that the pathway to violence is a most. It's an occasional. It's a few. So I don't think that they're to admit this as reliable under Rule 702 in any matter, I think is inappropriate.
Okay. All right. All right, the issue before the court is whether Ms. Amon's proffered expert testimony should be excluded in its entirety. The motion is made under Rule 702 and 403 of the Utah Rules of Evidence. The court addresses Rule 702B first. It provides that Scientific, technical, or other specialized knowledge may serve as the basis for expert testimony only if there is a threshold showing that the principles or methods that are underlying in the testimony are reliable, are based upon sufficient facts or data, and have been reliably applied to the facts. Here, first, it bears noting that Ms. Amin is being offered as a blind expert. She is speaking about general principles, not applying a framework or analysis to the specific facts of this case. Moreover, her testimony is based upon a retrospective study of killings that actually occurred. And based upon that retrospective study, her testimony identifies some commonalities that exist among completed killings, while also acknowledging that people that begin on the so-called pathway to violence often fall off at any of the stages, sometimes begin again and then fall off again. That just because they begin on the pathway does not predict or mean that they will complete a killing. Under Rule 702A, the court finds that based upon her education, training, and experience, as shown in her CV, Ms. Amin is qualified as an expert in this field. And the court finds that her testimony based upon that retrospective study is sufficiently reliable and based upon a sufficient set of facts or data, given her description of those retrospective studies and their updates over time, to satisfy the minimal threshold for reliability under Rule 702B for a blind expert. The real issue is whether her testimony would be helpful to the trier of fact under Rule 702A, and under what circumstances. To be clear, under cases like United States versus Wells, 879 F. 3rd 900, which is from the Ninth Circuit in 2018, Ms. Amin's testimony cannot be used by the state in its case in chief as substantive evidence of guilt. And even if she's called as a rebuttal expert, the state cannot refer to her expert testimony as a basis for the jury to draw comparisons that would weigh in favor of a substantive finding of guilt. However, in the event that the defense makes an assertion in its defense case that is categorical and general, for example, something to the effect of that it's simply not credible that a person would engage in a weeks-long campaign to kill another person in the absence of an imminent threat to their safety, then Ms. Amin's testimony regarding the retrospective study of completed killings showing a feature such as a preparation and plan over time would be helpful to the trier of fact under Rule 702A to rebut that generalized categorical assertion by the defense. If the defense makes an assertion to the effect of Kouri Richins did not commit these crimes, and one of the reasons you can be sure of that is because Kouri Richins had so much to lose in her personal life and her family life if she had, that is a case-specific level that Ms. Amin's testimony would not be helpful in rebutting. However, if the defense makes a absolute or generalized categorical statement regarding how homicide unfolds or whether it ever unfolds as alleged in this case, Ms. Amin's testimony would be helpful to the trial of fact in rebuttal. And it would not be unfairly prejudicial in a way that substantially outweighs its probative value. because it would not be able to be used by the state as substantive evidence of guilt. Rather, it would only be used to rebut the defendant's categorical assertion regarding features related to homicide. The court acknowledges that pursuant to this ruling, the likelihood that the defendant is going to make such a categorical high-level argument is pretty low, which means that the likelihood that Ms. Ammon will ever be called to testify is also pretty low. But fact remains that there is not a basis to grant defendant's motion in full, because there is a cognizable basis upon which her blind expert testimony would be helpful to the trier of fact under Rule 702A, and which its probative value would not be substantially outweighed by the danger of unfair prejudice under Rule 403. So, the defendant's motion to exclude Ms. Ammon's testimony is granted in part and denied in part. She cannot testify in the state's case in chief. The state cannot use her testimony, even if it comes in rebuttal, as substantive evidence of guilt, either directly or by inference. And her testimony would not be helpful to the trier of fact to rebut case-specific assertions of why Kouri Richins did or did not commit the act she's accused of. However, if the defendant makes a categorical assertion regarding how homicides unfold, the court will revisit this issue to determine whether Ms. Ammon's testimony should be allowed in rebuttal. Let me pause there for a moment. Ms. Shervinack, do you need any clarification of the court's ruling?
No, Your Honor.
Ms. Lewis.
No, Your Honor.
Okay. Ms. Lewis, where would you like to go next?
What do you do, Throckmorton?
Yes, we're Mr. Throckmorton would be
Okay.
next. So Ms. Nestor will be. Do you want to move or are you okay there?
Ms. Nestor, I have looked at Mr. Throckmorton's report from June of 2023 and his amendment in March of 2025. I'm really familiar with him from other cases in terms of his background and his method. Tell me what you see as the problem in this case.
So, Your Honor, can I come to the,
Wherever you're
I
comfortable,
hate bending
please.
over to
Yeah.
reach that microphone. May it please the court, good morning. Your Honor, as far as Mr. Throckmorton's testimony, the objections that we have to his testimony, it's basically focused on the first prong of 702, which is whether or not his testimony can be of any assistance to the finder of fact. And the main concern is his conclusions or lack thereof are basically, I looked at this. I cannot say at all whether Kouri Richins signed Eric Richins' name or didn't. I can't
Right.
say she did. I can't say she didn't.
Right. You skipped a step though.
Right. Well, I'm getting.
I mean, he does say with a much higher level of
Right.
probability
Right.
that Eric Richins didn't sign it.
Right.
He just
So-
can't say that it was with the same level of probability or any, depending on the document,
Right.
that it was Kouri Richins that made the simulated forgeries.
Right. And the concern that we have is his materials that he provided and that we expect would be laid forward before the jury.
So I can probably let y'all know that I think that our other hearing is probably gonna be getting together. Hey lady, how are you? And we are going to be moving over to our school trial. Let me see. They haven't started just yet. but I got it scheduled for like 12:30. So just so y'all aware, I guess I can't do much with this. I don't know what they arguing. I don't even know if I really care at this point in time. So yeah, there, y'all have it. I'm being honest.
Jury, um, take little pictures of letters and compare them. And, you know, all of us are human and we all have eyeballs, and or those of us blessed with the sight have eyeballs that work. And we are tempted to look at those things and compare them and contrast them. And it goes back into a jury room. And the bottom line is they're calling the expert to say, I cannot draw a conclusion that Kouri Richins signed these, signed his name, signed the initials. He even his finding that Eric, I believe the finding he had was a strong probability
For one of them.
that Eric Richins did not initial the documents. Not that he didn't sign the power of attorney, but that he didn't even, a strong probability he may not have initialed them, which is not even to the standard of, you know, beyond a reasonable doubt. It's not anything close to that. And the concern that I have is you're taking an expert who is going to basically say, here's all this stuff. I'm going to send this back in the jury room. Y'all can sit there and look at these initials. You can try to figure it out yourself if you think that he did it. But I'm, as an expert, saying I can't say Kouri Richins did.
Maybe pause there for a minute.
Yeah.
So my understanding of Utah law is that lay jurors can, in fact, compare signatures in the absence of expert testimony. That is something they're allowed to do.
They can, but the problem is you're trying to layer on top of that this expert who is giving an opinion that's a non-opinion to support a finding that the state wants, right?
Okay. Well,
And
maybe.
it's not supported by the science. The second prong that we're
Pause
attacking.
with me for a minute, though.
Yeah.
I apologize.
No, it's fine.
So the concept of the state showing documents and arguing to the jury, take a look at these. You can see with your own eyes that doesn't look like Eric Richins' signature. That is permissible argument, and that is a permissible way to admit that evidence, correct?
I think they could try that. I mean, they could do that.
Right. Okay.
Right.
Then we look at, all right, does Mr. Throckmorton's analysis assist the finder of fact in determining whether the state has carried its burden of showing beyond a reasonable doubt that defendant forged some documents, right? And a step along that way from the state's perspective is, well, first we need to show that Eric didn't sign them.
Right.
So focus on that moment, that part for me for a moment. Why isn't Mr. Throckmorton's testimony admissible on that part?
Well, one big reason is that the initialing, there is no statement at all that Mr. Richins, so there's two documents at play. There's a power of attorney, which according to Mr. Burmester from the county, they're not even going to get into that unless we introduce the power of attorney as an exhibit. They're not even planning on doing it in their case in chief, which I just found out this morning.
Okay.
But let's say hypothetically, for some reason, we need the power of attorney. They're not even saying he didn't sign it. Like, their expert is not saying that's not his signature. They're only questioning whether he initialed each and every little blank on the side, right? Of which the expert cannot say. He cannot say he didn't. He cannot say to any degree of certainty whether Kouri did. He said absolutely no conclusion as to whether Kouri did, but he also can't say for sure that Eric didn't.
Well, doesn't he say that there is a strong probability that Eric Richins did not author the ER initials on the power of attorney that defendant allegedly used to obtain a HELOC?
Yes.
Okay. He's used a strong probability for that opinion, right?
Right, but that also provides for the possibility that Eric did initial it, right? I mean,
certainly,
yeah.
And the jury can weigh his testimony.
Right.
In terms of admissibility, it would seem to be helpful to the trier of fact to receive an opinion from a qualified expert as to whether Eric Richins initialed the document or not, right? Because if he didn't, it leaves open the possibility that somebody else did. And then when we go to, well, does he have an opinion as to whether Kouri Richins was the one that initialed it?
Right.
I acknowledge that his level of certainty there is much lower, if not, there's no
Zero.
conclusive proof one way or the other.
Right.
But why wouldn't you want to let that in?
Right. Well,
I mean, if
he
the state wants to
testifies,
call him to say it, it certainly doesn't hurt defendant.
yeah, if he testifies at all, trust me, we do want that to come in.
Yeah.
The concern that I just have is just misleading this jury about these floating standards, because under the National Institutes of Science report, under the PCAST reports, you know, the reliability of subjective handwriting analysis has been brought into serious question by the general scientific community. I provided those materials in my brief. And to have a layer of persuasion going to the jury of an expert that is relying on a science that has not been generally accepted by the national scientific community. And I specifically identified where in the NIST report and where in the PCAST report the scientific community says, look, this is just a subjective. It's no better than if me and you and the deputy all sat down and just guessed if it looked like it matched.
Doesn't Mr. Throckmorton reference studies saying that certified handwriting analysts are better than the lay public at identifying differences in simulated forgeries?
He does, and we would obviously attack that if he took a stand vigorously. But yes, he does. He states that in his report, which, you know, may be enough to get you past the gatekeeping requirement. That's up to the court. I do also have some real concerns about whether portions of this needs to be redacted. One of the conclusions he was asked to, or he wasn't even asked, he did it sua sponte, I think only applies if it's a court, but he did it on his own when he was submitted the documents in question. One of the documents he was submitted on the amended report as recently as a few months ago. You know, now we're 3 years after the death, and he's just now being submitted new evidence, right, to evaluate. But that's what happened. And they gave him a report by the like a notary page where the notary had signed, and he just on his own makes a conclusion that a date has been altered, a number, not a letter, not handwriting. There's no evidence whatsoever that either that was asked of him to do, that he's qualified to do that there's any science backing that up.
I don't know that the state's offering that opinion at trial. Am I right about that, Mr. Burmester?
I don't even know what she's talking about.
Okay, so it sounds like a no.
Okay, well then
Okay.
if that report comes in, we're going to ask to redact that section of
Reports
it.
don't come in, they're hearsay.
Okay.
His demonstratives may come in.
Okay.
He usually has, he does in fact have demonstratives, and those will need to be disclosed to the defense, but the report's hearsay.
Right. And also whether or not, I mean, that'll go to wait. We'll deal with that when he takes the stand. So I think really that it's really a two-based argument that we presented to the court. Two bases for our argument. One is that we don't believe it's helpful because there is no conclusion. Number two, we question the science of handwriting analysis. I provided the court with the scientific community's concern about the reliability of handwriting analysis, that it's really slowly but surely being relegated to junk science. And on that ground, we think, and what it adds is minuscule. It provides no guidance to the jury. So as far as we're concerned, if you're going to exercise a gatekeeping function at this point, this would be the point to do it. And we would ask that he be prohibited from testifying as an expert in this case.
Okay, you'll get the last word.
Yep.
Mr. Burmester.
To clarify, the state would offer Q1, Q2, Q4 in the event arguments come out in the defense case in chief. I don't know. We come up with 100 hypotheticals, but maybe something. She's a great businesswoman.
Okay, guys, I see where they have started in the other courtroom. Are y'all okay if we move over there? I mean, since this started. Here is the link to the room. If everybody wants to head over there, if you click on that link, it will teleport you over there and we can listen to the arguments in regards to what are we going to do with this information, this Brady information that was not provided to the defense. What kind of stink are they going to put up? If you guys want to head over there, we heard some of this. I'm okay. Yeah, we'll head over there. All right, guys, I will see you over there. Thank you. We are going to our, motions hearing. Oh, look, they calling it a motions hearing. Like, dang, that's messed up. All right, here we go.